talking to the veteran lawyers of the NPZ Law Group, providing you the A to Z of US and Canadian business, family, and employment-based immigration law at your service in New Jersey, New York, Indiana, with affiliated offices in India and Canada. So Gagan, not to make light of this, but we are mostly familiar as lay people with in-laws and outlaws. So what is this about inland or outland spousal applications in the Canadian immigration context?
Yes, thank you, Vijaya. That's a very interesting scenario that I come across very frequently. Broadly, if you're a Canadian citizen or a permanent resident, you're 18 years or older, you can sponsor your spouse living in Canada and outside of Canada. Now, the spousal applications in Canada are broadly classified as inland and outland applications. If both spouses are in Canada, we select inland. If both are, either of the spouses are outside of Canada, we file outland applications. And it's very important to have a distinction between these two kinds of applications in the beginning of the process. So in a scenario where foreign spouse is in Canada with a Canadian citizen, they have to meet the test. Number one, marriage is genuine. And number two, it is not for immigration purposes. So in real life situation where a foreign spouse is on a valid work permit, study permit, or another immigration status such as refugee status, and their visa application was either denied or is expiring soon, and then they marry, the officer will look at the bona fide intent of the marriage very closely. Whether it's for immigration purposes or not. This is very common, Vijaya, when officers are dealing with such applications. And also, it may sound very stereotyped, but the officer is looking into their religious, cultural, educational, employment, age compatibilities between the spouses. Otherwise, we would know that sometimes these factors don't even matter in a marriage. So the visa of the foreign spouse is an important factor in such kind of inland spousal applications, in addition to other requirements. We now move to the next scenario where a Canadian citizen or a permanent resident is living with foreign spouse outside of Canada. They may be living here in US, for instance. In this situation, the applicant should establish that they intend to return to Canada once the application is approved. Such evidence includes looking for a rental property in Canada, applying for jobs or already have a job offer in hand, resign from the positions they are holding in foreign country, or in the process of selling the house they have in the foreign country. The officer is going to look into all these factors simply because the government does not want to give PR applications, PR status to foreign spouse easily. Why? Because the PR holder can then continue to extend their PR status indefinitely. Otherwise, as a PR holder, you have to be in Canada for 2 out of 5 years to maintain your PR status and extend it for future extensions. So here are some of the nuances which we feel the listeners should be aware and make right choices at the time they're filing the applications.
Absolutely, that is so eye-opening, and thank you for that. For those insights, and of course, thank you so much, Gagan, David, and Ludka for sharing all of those valuable advice and insights. Can't thank you enough for making the time. That were attorneys David Knockman, Ludka Zimovchek, and Gagan Mundra of the business and family immigration law firm NPZ Law Group. For all your US and Canadian immigration issues, call them now at 201-670-0006 or just log on to visaserve.com. I'm Vijaya, keeping you current and up to date with the law and life. Until next time, keep it right here on Mirchi. It's hot.